So hello everyone. Now I hope we are recording, we have the mic, we have the camera. I'm always afraid I'm going to forget one thing, but I think we're all set. So my name is Anna Srawin-Corali. I'm a teaching assistant at the Geneva Academy, for those who haven't met me yet. And you are attending the event that it's called Special Tribunal for Aggression Aboard the Risk. So in case you are at the wrong event, you can still escape. There's still some time. Mr. Putin clearly justifying the invasion in Ukraine as a need to protect the sovereignty of Russia. And I think that since then we are all aware that really numerous international, regional, and also national institutions have repeatedly stated that Russia has committed an act of aggression against Ukraine. But what is more, it's also that all these institutions have repeatedly somehow indicated that crime of aggression has been committed by various individuals and that these perpetrators should be brought to justice. Now, on the one hand, I somehow believe that we all agree and that there is also general agreement, if you like, that the primary responsibility really for these crimes that have been committed, one of them being crime of aggression, should be tried in Ukraine and other domestic criminal jurisdictions, right? This could be assessed again whenever the crime would arguably amount to the crime of aggression, under, for instance, definition of the definition of the crime of aggression, for instance, as it exists in the Criminal Code of Ukraine. And here you have the definition, okay? This is just one example. If you have the time to read it, you can see that the way that the crime of aggression is phrased in the Ukrainian Criminal Code, it really can capture even an ordinary soldier. And to my knowledge, at least, the majority of charges that, at least at the beginning, the Ukrainian prosecutor actually did suggest were with respect to ordinary soldiers. Okay? Now, on the other hand, I'm also somehow convinced, or let's say that there's been a lot of discussion with regards to the international criminal justice, if you like, in the narrow sense, for the crime of aggression. For really those perpetrators that are, if you like, big fish, so it's difficult to catch them at the national criminal jurisdictions. And in this regard, I'm sure all of you have heard, I guess this is why all of you are here, about the Special Tribunal for Aggression, okay? Now, this Special Tribunal for Aggression, I think, have also somehow woken up a lot of excitement, let it be from the positive side, but also lots of concern. And this is actually why we're meeting here today, to discuss some of these concerns, but also to understand what in reality this tribunal has somehow, which expectation has raised in the Ukrainian society, okay? With this, I'm really, really excited to say that I have, absolutely really distinguished panel today, which we will introduce in depth in a second. But just briefly, so this is Natalia, I never know how to say it. Natalia, okay, I will try my best. Handel, then we have Lorenzo Palestini and Patrick Labuda, and we will introduce you all in detail. And of course, I forgot to introduce my co-moderator, Francesco Romani, which I was supposed to do at the very beginning. But Francesco has co-organized and co-moderated all the IHL talks with me so far, and it's been great. So yes, I really look forward to the discussion. Before we kick off really with the substance, I just want to clarify the modalities for those who maybe have never attended IHL Talks. So first, we will start with the panel. So me and Francesco will be asking some questions to our panelists, and then it's going to be your moment, so prepare your questions. So we will have a Q&A session, and we will be giving you the floor, and you may ask whatever you like to our panelists. Okay? Perfect. I think we're all ready. So I'm going to start by you, Lorenzo. So to briefly introduce you, Lorenzo Palestini is a lecturer and also researcher at the Geneva Center for International Dispute Settlement. He also has been a counsel of the Colombian team before the International Court of Justice. And one of the things that I think it's really worthwhile to mention as well is that his monograph entitled The Protection of the Legal Interests of Third States in Maritime Delimitation Proceedings has just been awarded the 2021 Paul Guggenheim Prize. Lorenzo, welcome. For you, and now I'm going to sit down so I can look at you at the same level, but hopefully the ones who are at the back can still somehow see me. For you, I have a question regarding the law on immunities, okay? So as you surely are aware, since the very beginning of the discussions on the Special Tribunal for Aggression, many have highlighted that creating such a tribunal could be problematic because it could arguably raise concern regarding some immunities that potentially, so basically state official or state officials have before domestic criminal tribunals, or even, in the view of some, before international criminal tribunals. Now, I wonder whether you could maybe expand, you could clarify for us what could be really problematic regarding the law on immunities when it comes to this Special Tribunal for Aggression. Maybe we start with this. Do you prefer?
Thank you very much, Anna. Thank you very much, Francesco, for inviting me. The commute was not too long because we shared a building with the Master in International Dispute Settlement and the Academy of Humanitarian Law. It's good that we do things together, and there will be another conference soon, still about Ukraine, which is a shared project, let's say a shared event of the two programs. I must say that I hesitated a lot about participating in this panel for two reasons. One reason is that, as you probably noticed from the introduction, I'm working in a program in which we deal with interstate dispute settlement and some private actors to state dispute settlement, but mainly investor-state dispute settlement. So not much humanitarian law involved in this program, not at all. But of course, international humanitarian law, international criminal law were topics that always attracted my interest. And the topic that I'm discussing today is a general international law topic, I would say, the law of immunities. And well, so I accepted. It was also difficult, I must say, because from the video that you just displayed, we can immediately realize that we're discussing a very sensitive topic. It's a bit difficult sometimes to provide a position based on the law in such a delicate conflict. But precisely because we're dealing with a delicate conflict, I think one has to be true to his own viewpoints and should not be affected by the issues, the substantive issues involved. Not too much, at least. So this probably foreshadows some of my views that are a bit, perhaps not the most popular, at least in the Western hemisphere. Somebody's trying to get in, I guess. But oh, okay. Good. Very well. So Anna asked me a question, which is basically, if I followed well, does the international character of a tribunal has any bearing on the question of the existence of immunities, notably of the head of state or officials of the state, and potentially the state as such? Which is a big question, which I will not answer directly, otherwise my intervention will be over very soon. But I could say that another way of putting it is, does it make a difference whether the tribunal dealing with exercising its criminal jurisdiction is a domestic tribunal or an international tribunal? And a very simple way of putting the question would be, do I agree basically with the International Criminal Court Appeals Chamber's decision in the Jordan referral case relating to al-Bashir, who was the president of Sudan? Because, yeah, basically if I say yes or no, I basically gave my answer, I think. But the question is a question of immunity, but it's not only a question of immunity, because what we have here is the crime of aggression. And the crime of aggression brings in also a debate as to whether we can separate the responsibility of individuals from the responsibility of the state as such. This is a general question, I think, in relation to international criminal law. Most of the time, if you are convicting an individual of genocide, of war crimes, that individual is probably acting on behalf of a state. And what you may say in relation to that individual might have an impact, more or less obvious, on the responsibility of the state as such. This is all the more obvious in relation to the crime of aggression, and we'll get back to that in a moment. But to start things easy, I wanted just to structure my presentation around a few dichotomies. I think dichotomies are always helpful to structure a presentation. But here today we will be discussing both immunity from jurisdiction and immunity from enforcement, immunity from execution, arrest of people, detention of people. So this is the first dichotomy. We also have to bear in mind that when we speak about the law of immunities, you're thinking about criminal jurisdiction. But there is a law of immunity also in relation to civil and administrative jurisdiction. And in fact, if we talk about the state, criminal jurisdiction is pointless. You don't exercise criminal jurisdiction over a state. You can exercise civil jurisdiction, provided there are no immunities, of course, and you could exercise administrative jurisdiction in relation to a state. Another dichotomy, which of course is important, is the one between international criminal tribunals and domestic courts. The last dichotomy that you have to bear in mind, perhaps, is what we call sometimes personal immunities and functional immunities. Personal immunities being immunities attached to people, regardless of what they are doing, in what capacity they are acting, and functional immunities, of course, are immunities that relate to acts done in an official capacity. These are all important dichotomies, and to close the introduction, I should say that there is not one regime of the law of immunities, but there are many regimes. We could talk about diplomatic agents, we could talk about consular agents, special mission agents. All of these are special conventions regulating these immunities. We could talk about head of states, head of governments, minister of foreign affairs. We could talk about the state as such. We could talk about international organizations. We could talk about high officials in international organization or the normal personnel of an international organization. All these people enjoy immunities, but they enjoy different kind of immunities. They could be immunities from criminal jurisdiction, civil jurisdiction. They could be immunities that are very, very important in terms of personal immunity, or they could be immunities strictly related to the job they're doing for a state or an international organization. The last category I could mention, and this is somewhat controversial, is whether there is a law of immunities that applies to all agents of the states in the same manner. And if you followed a little bit the debate at the International Law Commission, there are first reading draft articles that have been adopted, and they are on the immunities of state officials. And there is a big question there because some people believe you cannot discuss immunities of state official in a general sense because there are only special regimes, you could say. And the special regimes, of course, I gave you the example of the diplomatic agent or the consular agents, but people will tell you that the law is different if you're a spy. The law is different if you're an armed force, if you're a soldier, either a soldier that is stationed in another territory or a soldier engaged in military hostilities. There are people who believe that all these categories of agents have different immunities. So it is already a bit controversial to say that there is one law of immunities that apply to all the agents of the state. Now, of course, what are we going to talk now about? We're going to talk about the head of state. We're going to talk about agents of the states, because I don't think that the Commissioner on Children's Rights, which has been, has just been sent a nice letter, I don't think she can belong to the category of head of state, head of government, or other important ministers. So you can imagine it's not the same law of immunity that will apply to this person in comparison to the president of the Russian Federation. And of course, we're going to talk about criminal jurisdiction, but I'm going to draw some parallels with civil jurisdiction because I'm going to talk also about state responsibility and state immunity. Now, I move to because time flies and there is always time to discuss, I move to two important, let's say, two or three important issues. The first question, which I think is very important and is really at the center of everything, is whether the law of immunity is procedural in nature or substantive. Because it has a dramatic impact on whether you believe there can be exceptions. And I should probably not speak about exceptions because that already gives you an idea that I believe immunities are the rule and absence of immunity is the exception. But that's actually open to debate. But immunity as a procedural bar, if you follow the International Court of Justice approach when it spoke about state immunity in the German versus Italy case, told some things that are quite important and have strong repercussion. It said that because the law of immunity is procedural, basically the gravity of the crime that we're discussing is not really a relevant consideration. Why is that? Because even if you were to argue, for example, that Hughes Cogan's norms have to take priority over other norms of international law, the ICJ would tell you, well, one norm is substantive, the other norm is procedural. You might not like the result, but there can be no conflict between a procedural rule and a substantive rule. Bear in mind that the court here was talking about state immunity, and what it said didn't necessarily apply to other kind of immunities. At the opposite side of the spectrum, there are people who argue that immunity are substantive law defenses, meaning it's not a procedural bar, it's a substantive law argument, and it would go more or less this way. This individual cannot be responsible for its actions, because these actions should be solely attributed to the state for whom it is acting. This seems terrible from the viewpoint of international criminal law, but actually it's not too bad, because if you build the argument this way, as a substantive defense, then you can always say, well, but what if international law criminalizes the conduct of individuals and not just the state? If it does that, then you could say that immunity does not apply as a defense in relation to international crimes. Okay? You follow me on this? And I'm not going to give you my answer, but I suspect that the point is that there is a little bit of truth in both approaches. And I suspect that we could probably say that some immunities are more procedural in nature, while other immunities are more substantive in nature.
So if I can ask you,
Yep.
for instance, if we think specifically about the Special Tribunal for Aggression, what would you say in that specific case? Let's imagine that Mr. Putin would be, or there would be an option, so we would say clearly, as you said, let's say that the tribunal would have jurisdiction, but then how would you define this then as a procedure or substantive
Yep.
type of immunities, if you like?
So it depends a bit, I would say, on whether we're talking about the president of the Russian Federation or whether we're talking about the Minister of Children's Rights. I would say that ratione materiae immunities, meaning immunities that only apply to acts done in official capacity, immunities that would apply to a large spectrum of agents of the state, I think there is room to argue that they should not be seen in a purely procedural way. They should be seen in a more substantive manner, and therefore there would probably not be a bar. The problem here, of course, with crimes against crime of aggression is that there is a question, though I understand that Ukrainian criminal code is probably saying something different, is whether low official or not very high-ranking official can even commit a crime of aggression.
But then you think, because I think that's an interesting question, which I clearly forgot to address, because I knew I'm going to forget to address something, is right, which definition also this special tribunal would apply. And at least when I was looking through the discussions on these, and maybe we can discuss this in the continuation also, but majority would say, well, in reality, most likely, this would be the only internationally agreed definition of the crime of aggression, which is in the Rome Statute. which would be this one. Okay, apologies because the technology is simply my thing. It's always on my side. So as you can see here how it would be phrased, it seems to me that, apologies Patrick, that the way that crime of aggression is phrased in the Rome Statute, any of the special tribunal really applies this definition. It rather can be only somebody who has de facto or de jure either military or political control over state. So it seems to be somehow restricted, no? I find it interesting. Do you think this could have any effect also on immunities then? Yes, sorry.
Thank you. Well, this is a question that I'm probably not the greatest expert to discuss it, and I suspect my co-panelists have a view. But of course, this brings in the point that we were mentioning before, is that crime of aggression is perhaps the crime that has the strongest state implication, meaning that it's really, we can discuss. It used to be a discussion whether individuals can be tried for crimes of aggression. It was done, I understand, by the Nuremberg and the Tokyo tribunals. But for a long time, crime of aggression, if you look at the General Assembly resolution on the matter, it's not discussed as an individual crime. So the Statute of Rome, in its interesting way, regulates it through the amendment done in Kampala. And I'm not the best one to discuss the point, but what I could say is that here it brings the issue of the connection between individual and state responsibility. So this tribunal, this international tribunal, but let's even imagine a domestic tribunal that were to exercise jurisdiction over an individual for the act of aggression. Can it do so without assessing the responsibility of the state? I have very strong doubts because the way I saw the definition in Article 8 bis, I think, of the Statute of Rome, it shows that you first have to establish there has been a violation of the UN Charter, a manifest violation of the UN Charter. So in a way, the gateway to individual responsibility is a preliminary finding of state responsibility, which brings two issues. It brings an issue of jurisdiction, potentially. Would a special tribunal have the jurisdiction to try Russia as a state, in addition to trying its president? And more importantly, now we have two regimes of immunities that would be applicable. We have the regime of immunities applicable to the head of state, and we have the regime of immunities applicable to the state as such. And I should probably not say too much more on this because I think my colleagues will discuss this point too. But to conclude on the question of immunity, to try to give you an answer and then I can motivate it a bit more, I strongly disagree with the ICC position in the appeals chamber referral of the Jordan refusal to cooperate in relation to al-Bashir. I strongly disagree because I don't see the line of reasoning. I don't see the line of reasoning because I don't understand why an international criminal tribunal that has been established by a group of states can bypass immunities when in fact a domestic tribunal probably cannot. There is a problem, I'm not taking it in the best line of reasoning probably, but you know what the ICC did. ICC said there is no rule of customary international law telling me that head of states, incumbent head of states, have immunity before international criminal tribunals. This was a very clever way of proceeding to an assessment while ignoring the practice of domestic tribunals, which do not exercise criminal jurisdiction over Gaddafi, Fidel Castro, or who else? A few other people, certainly. So what is the logic of drawing a distinction between an international criminal tribunal and a domestic tribunal? I personally don't see it. The ICC said that it was acting on behalf of the international community. Maybe. But wouldn't a domestic court tribunal also be doing the same in a way? I'm not sure. To conclude, basically, but I can get back because there are issues of jurisdiction, but I noticed that Patrick is going to address them, so I don't want to touch on them. I believe that soldiers do not enjoy immunities for international crimes before foreign courts or international criminal courts. No distinction there. On the other hand, I have a very different view of the category of head of states and the highest ministers in a state. I believe their immunities, personal immunities, that are supposed to protect them not only from the act done in their function, but even their private acts, they should not be tried by foreign courts or by international tribunals that have been established without the consent of their home state. And we could discuss Chapter 7 tribunals and all of that, but I think this will come up in the conversation.
Perfect. Do you mind if we continue and then we
Absolutely.
can go back to it? Could you give me the microphone? Sorry. No, thank you so much, Lorenzo. And since I see many of our students here, I'm sure you're now completely confused because I think this is already the 5th or 6th different use of immunities that you get. But I think that's great. That can make you reflect and make up your own mind. So thank you so much for this great intervention, Lorenzo. And I think it's really about time to pass the word to Francesco.
Thank you, Anna, and thank you, Lorenzo. We're now getting closer to the ground somehow, to the Ukrainian ground, and we're going to do that through the help of Natalia Handel, who's sitting here beside me. So Natalia is an expert and a trainer on international humanitarian law at the Ukrainian Red Cross Society, the Training Center for the Prosecutors of Ukraine, the Higher School of Public Administration, and the Ukrainian Helsinki Human Rights Union. She's also a professor of international law at the University of Odessa and a research fellow here at the Geneva Academy. And the first question that I would like to ask to Natalia is, how has the Ukrainian civil society reacted to this idea of the Special Tribunal of Aggression, which, to my knowledge, was an idea that was first aired at a Chatham House meeting, so in a very UK context-led, in a UK-led context. How has the Ukrainian civil society reacted to that and also contributed to the evolution of this idea?
Thank you for this question, and thank you for this interest for this topic. And it's very important for Ukraine, and Ukrainians are really important for me as a Ukrainian. How this idea came about and sent to whom? It was born in a conversation between Foreign Ministry Dmytro Kuleba, Ukrainian judge Mykola Gnatovsky, and well-known international lawyer Philip Sands, who is a great friend of Ukraine. And his relatives come from the small town on Zhokva in western Ukraine, which you can read about in his book East-West Street and learn a little more about Ukraine. Thus, on 1st March 2022, Foreign Minister Dmytro Kuleba presented a statement by Ukrainian and foreign lawyers and politicians on the need to establish such a tribunal. Why did this idea come about? Because on 21st February 2022, the whole of Ukraine woke up at 5 a.m. on attack from Russia. The war came to everyone. The war woke up every family, every child, and whole country. For more than 1 year now, the war caused by Russian aggression has affected every Ukrainian. The whole of Ukraine is a victim of aggression, and every Ukrainian is a victim of aggression too. Several more generations will hate Russia and strive for justice. 5 a.m. is a very symbolic time to Ukraine because it marks the beginning of a war, both the 1941 Second World War and the full-scale invasion of Ukraine by Russia in 2022. But the aggression has been going on for more than 9 years, and this is important to respect the memory of all of the victims of the war. The first time I personally realized that there was an international armed conflict in Ukraine was when I received the news of the death of my classmate in Ilovaisk in 2014. He was a bodyguard. At 5 a.m. On the 21st February 2022, all Ukrainians changed. 5MA united us for the sake of our country, for the sake of our families, children, and for the sake of our future. Throughout the history of Ukraine, we have never been so united in our desire to defend our country and bring to justice all those who commit international crimes against our fellow citizens and our children. On one day, the state authorities, civil society, and everyone come together in Ukraine. All contradictions, disputes, criticism became unimportant in the face of the aggression, and Ukraine survivors, as was in the unity of Ukrainians and the incredible support of the foreign states, nations, and people who stood solidarity with Ukraine and Ukrainians. Therefore, the idea of special tribunal is about justice and the Ukrainian desire for accountability for the aggression against Ukraine. Immediately, human rights organizations united and two coalitions were created in Ukraine. The first one is called the Tribunal for Putin. For example, it includes the Center for Civil Liberties, last year Nobel Prize nominees, and the Ukrainian Helsinki Human Rights Union. The second coalition is called 5AM Ukraine and includes 31 Ukrainian human rights organizations. What unites this coalition is a common goal, is accountability for international crimes, the responsibility of Russian state as a violator of a number of international obligations. What do they do to achieve this goal? Firstly, they document violation on IHL and human rights, because there are a huge number of such violations. Just one fact demonstrates the scale of these crimes. For example, 75,000 criminal proceedings for war crime now is open in Ukraine. A violation of Article 438 of the Criminal Code of Ukraine as war crimes. Secondly, they spread knowledge about IHL among very different groups. It's a very big request to know about what is IHL, how IHL protects victims of war, and what's the responsibility for this violation. The third, they prepare proposal for change to Ukrainian legislation. You can see the Article 437. This article has a lot of disadvantages. That's why a lot of laws in Ukraine should be changed. Third, firstly, they conduct advocacy campaigns on the importance of prosecuting international crimes in Ukraine. Fifthly, they help victims of the conflict, and the list of these activities could go on. My colleagues from Ukraine, prosecutors, investigators, lawyers, human rights defenders, bodyguards, diplomats, have been working 7 days a week for more than 1 year. We don't know what holidays and weekends are, and it's commonplace to hold a working meeting, for example, on Sunday, and not to mention the time because there is always some violation on IHL, and that request qualification, reaction, and certain legal action. Russian attacks on Ukraine and the crimes that resulted from it date back to 2014. Since then, Ukrainian NGOs have submitted dozens of information materials to the ICC Prosecutor Office, which have been used to prepare preliminary examination reports. Ukraine Human Rights Organization insists that the conclusions of this report should also be taken into account, and that the cases investigated by the ICC should not be limited to the events of 21st February 2022. In addition, in order to bring to justice international crimes committed on the territory of Ukraine through universal jurisdiction, Ukrainian NGOs are ready to share the information necessary for this work through for example, the mechanism of the EU Genocide Network. Therefore, the issue of responsibility is about the value of justice, law and international law. And it's for these values that Ukraine and Ukrainians are fighting now. From 23 to 26 December 2022, a survey was conducted in Ukraine on the legal protection of victims of Russian war crimes, with 2,000 respondents taking part. The survey was conducted by the Ukrainian Legal Advisory Group. The survey included a question: have you heard anything about the initiative to establish a special international tribunal for the crime of aggression against Ukraine? 59% of respondents answer, yes, I know it well. 15% of respondents answer, yes, I have heard something about it. 26% of respondents answer, no, I have not heard anything about it. The next question was, in your opinion, should this tribunal be only the crime of aggression, or should it also be for war crimes, crimes against humanity, and the crime of genocide? The answer was 2% of respondents answer, should only consider cases of aggression. 96% of respondents answer, should also address other war crimes, crimes against humanity, and the crime of genocide. 2% of respondents answer, hard to say. Another question was, in your opinion, which countries expert should investigate the crimes of aggression against Ukraine? The answer was 2% of respondents answer, only from Ukraine. 2% of respondents answer, only foreign specialists. 95% of respondents answer both Ukrainian specialists and foreign specialists. And 1% of respondents answer, hard to say. This survey demonstrated how Ukraine needs accountability for the crime against, for international crimes, including crimes aggression. Thank you.
Thank you. And I think these data are really interesting, and I guess Patrick will also comment a little bit on that, but they should definitely be taken into account whenever there's an idea of how to structure any models for jurisdiction. As a tiny follow-up to my previous question, I wanted to ask you, students here are probably familiar with the debate about whether accountability is an obstacle to justice. What's been the perception of that question in Ukraine?
The most expectation of the Ukrainian people is to achieve sustainable peace. You never think about what peace means until you hear, see, and feel war. The Ukrainian people are aware that peace can only be achieved on this basis of justice. Its integral elements are bringing those responsible for international crimes to justice and compensating victims for moral and material damage for the most serious crimes committed in this war. Maybe it's my thank you.
Thank you very much, Natalia, and I will now hand over the microphone.
Thank you, dear Natalia, for this really passionate speech, which I think we all really appreciated. And yes, I find it interesting that this survey also showed that, I mean, there is a support of civil society even that this special tribunal would be able to adjudicate all other crimes, no? So I think that's what I understood, right? You said this is, so I think this is interesting because we know, no, that the International Criminal Court in reality could have, I mean, has jurisdiction over war crimes and crimes against humanity clearly, and genocide in Ukraine, but the crime of aggression, the big issue that we have when it comes to the International Criminal Court is the fact that neither Ukraine nor Russia have ratified the so-called Kampala amendments. And speaking about the International Criminal Court and international criminal justice, I think it's just the right time to introduce Patrick. Patrick, I'm super excited to have you here because, you know, at some point in the past, he was sitting where I'm sitting, I guess, as a teaching assistant. How many years was this back?
Well, yeah, I think I left 5 years ago, so it's been a while now, yes. Yeah.
So someday I will be sitting where you are sitting, hopefully. So Patrick Labuda is a postdoctoral research fellow at the University of Zurich. Before that, he had been an assistant professor at the University of Amsterdam, right? And before that, he was a teaching assistant at the GM Academy. So I'm very happy to have you here, Patrick. And for you, I'd like to ask you some questions regarding the selectivity and legitimacy, okay, of international criminal justice with respect and in connection to the Special Tribunal for Aggression. So specifically, since the discussion on the Special Tribunal for Aggression have started, there has been many scholars, academics, practitioners, whatever you like, which would say that somehow disproportionate attention has been given to the war in Ukraine if you compare it to other wars. And what I wonder is, how do you see, basically, how do you see this attention? How do you see, what do you think this shows us about legitimacy and really selectivity of international criminal justice? Do you also feel that this shows that international criminal justice is still very much Eurocentric, and it also somehow still reflects the reaction, this division between the global south and north? So this would be my first question to you.
All right, great. Thanks so much. So I'm going to try and hold this because I have a tendency to actually use my arms, and that's not very helpful. Yeah, I mean, it's really great to be back. I spent 4 years in the attic writing my PhD, so it's really great to be sort of sitting here back in the Caseza room this time sort of on the other end and lecturing at people. Right. So thanks so much for your question. I mean, I'm going to offer some thoughts about selectivity in international criminal law, the Special Tribunal, and what it tells us really, I think, about the future of international criminal justice. And I'm going to begin just by stating the obvious. I think, surprisingly, I don't think it's really come up that much. The reason we're having this conversation about the Special Tribunal is because the International Criminal Court does not have jurisdiction to prosecute the crime of aggression in Ukraine, right? It has jurisdiction to prosecute war crimes, crimes against humanity, and genocide, but aggression, of course, is missing. And that's because of the peculiar jurisdictional setup that is now in the Rome Statute with the Kampala aggression amendments, right? And I'll come back to this in a moment. Now, in talking about selectivity, legitimacy, I want to actually disaggregate those terms. What exactly are we talking about when we critique the legitimacy of the Special Tribunal for Aggression, right? And I want to break it down along 3 axes. So the first sort of critique is that it's not really necessary to prosecute aggression because the International Criminal Court is already going after the big fish. And this argument is much stronger as of 10 days ago. Vladimir Putin, now we know, has been indicted. There's an arrest warrant for him. And so, the question is, are we just setting up a different tribunal, duplicating the ICC's mission? We're spending a lot of money. What for, really? And the benefit of all this will essentially be marginal, potentially, right? So that's the first type of critique that you will hear. The second critique that I'm sure many of you have heard by now, it's been over a year, is what about Iraq? What about Bush? What about Tony Blair? Why is it that we are prosecuting aggression in this case, but not in those other cases, right? And the critique here is about sort of double standards, Western double standards, and in particular the problem here is that the reason we have the Kampala aggression amendments with the jurisdictional gap that they create for Ukraine today is because those Western powers, the UK, the United States, France, pushed for that, jurisdictional regime, that regime that is the problem today, right? So Why are these states now pushing for an ad hoc tribunal? Maybe they should have thought harder when they were pushing for those Kampala amendments 13 years ago. Right, so this is essentially critique of double standards, that there is a double standard here. Western double standards are a problem. Then the last type of critique, I think you already mentioned this, right, is that there is too much focus essentially on Ukraine, right? Ukrainian victims are getting all this attention, but maybe we should be also worrying about victims in conflicts elsewhere, right, in other parts of the world. And so, the Eurocentricity concern. So those are the three critiques. I mean, I'm going to now turn to them and try and disaggregate them, or sorry, not disaggregate them, but actually engage with them. And before I do that, I want to say something something about my positionality in addressing this. I mean, I am from Eastern Europe, from Poland, right? I have family ties to Ukraine also. And I've spent the last 15 years almost of my professional life working on international criminal law in Africa. And so I come at this from a sort of a non-Western perspective, a Eastern European and an African perspective, and I'm trying to engage with these legitimacy issues from those two non-Western perspectives. And then, the other thing that I want to say about this is that I have serious doubts about the wisdom of this special tribunal, but for realpolitik reasons, right? Reasons of sort of pragmatism. Is it such a great idea that we are setting up this tribunal? Are we not boxing ourselves in? Is this going to make peace negotiations harder a few years from now? Happy to talk about that in the Q&A. I'm not going to talk about that now. I mean, I want to focus really on the selectivity issues, right? Or the selectivity concerns, right? These concerns that have been expressed with respect to the Special Tribunal for Aggression in particular, and I want to try and break it down and think together with you essentially. It's an invitation to discuss how should we think about these problems. So the first issue, right, the ICC, it's going to prosecute Putin anyway, right? Do we really need a special tribunal, right? And so, I do think that this is an interesting question, especially now that we know that Vladimir Putin has been, indicted. There is an arrest warrant, right? Are we not spending resources on something that is not that important? Or that's not that essential, right? And I do think that, it's really important to keep in mind here, what is the crime of aggression, right? If you go back to Nuremberg, and here I'm quoting from the Nuremberg Tribunal, that this is the supreme international crime because it contains within itself the accumulated evil of the whole. Right? And this goes to a point that, that Natalia made just a moment ago, right? Which is that not every Ukrainian is a victim of war crimes and crimes against humanity, but every Ukrainian is a victim of aggression, right? So the scope of the crime of aggression is much broader. It reaches farther, and it is in many ways, I don't want to get into a conversation here about whether it's worse than genocide, I mean, there are these debates, right? People can disagree about this, but aggression is an important crime. It protects a different interest, and it's something that needs to be acknowledged, right? And I want to also add here that I really think that this crime has a particular resonance in the region of Eastern Europe, right, for two reasons. Right? This is about undoing the pernicious legacy of Nuremberg, right? The Nuremberg Tribunal is considered sort of, in Eastern Europe at least, it's associated with Nazi guilt, right? And, me coming from Poland, I always remember, right, and this is oftentimes forgotten, that the Second World War didn't start just with Nazi aggression. There was a pact between the Soviet Union and Nazi Germany that started this war. And yet Nuremberg whitewashes that, right? It's about Nazi guilt. For us, it's also about Russian guilt, right? Centuries of Russian occupation, colonialism, and imperialism in Eastern Europe that have gone completely unacknowledged. And, this is an opportunity through the crime of aggression to address that issue, right? And so it matters, right? It matters. The crime of aggression is getting at something very different. I think, the hope there is also that this will help to dismantle the neo-imperial Russian psyche that we see on our screens every day. If you watch Russian TV, what the Russians are saying, what stories they tell themselves about their role in Eastern Europe, right? For us, this is the aggressor, this is the colonial power, and they still believe that Nuremberg exonerated them, right? And so again, I think that aggression is getting at something very important that other crimes cannot deal with. With respect just briefly to the resources question, I do want to just say that I think that a special tribunal for aggression would be relatively cheap. You're not building a tribunal like the Rwanda tribunal, the Yugoslav tribunal, where you're prosecuting hundreds of people. This is about a dozen people. The indictment is ready, essentially. We know what's going on. This would be quick and cheap, right? So the resources argument, as far as I'm concerned, is not particularly persuasive. But happy to discuss, right? Double standards, right? So let me talk about this a little bit, right? I mean, the double standards critique is the big one, right? What about Iraq? Why are we not prosecuting Iraq? Why would we focus on Russia here in this case, right? And I do think that, this critique is useful, right? Because it reminds us why we have the Kampala amendments. Why do we have this Rome Statute jurisdictional setup that gives the prosecutor jurisdiction over war crimes and crimes against humanity and not over aggression, right? And the fact is, we know why. It's the UK, France, and the United States, the Western imperial powers, right? And so it's good. It's good to bring this up, and it's good to point the finger at the West. And I think it's useful to have that conversation. Where I do have a problem with this critique is that some people seem to think that this is a recipe for not doing anything. We stop there. If we can't, this is essentially perfect is the enemy of good. If we can't prosecute aggression in Iraq, that means we're not going to prosecute aggression in Ukraine either. And that's where I really have a problem with this kind of critique, because if you look at who is pushing for the special tribunal, it's not actually the Western powers, right? I mean, if you listen to commentary about the tribunal, oftentimes this is presented as a Western project. In fact, it is an Eastern European project. It is Ukraine, it is the Baltic states, it is Poland that have been pushing very hard for a special tribunal. The states that do not want to get on board, that did not want to get on board until very recently are, you guessed it, the UK, France, and the United States. They've changed their position in the last 2 months, but they've done it because there's been a lot of pressure from Eastern Europe to have this tribunal, right? This is an Eastern European project. The Western powers are, not helping necessarily, right? And we need to think about it in those terms. It's great to talk about the West, but this isn't just a case of Western double standards. We do need to kind of disaggregate what is going on, really, who is pushing for this tribunal. And so, yeah, so I'll leave it at that. I'm happy to come back to this. I did want to say a few more things about this, but yeah, I'll leave it at that because I'm also probably going on for too long. I mean, the last thing that I want to say about all this, right, is that the last critique that I mentioned, that Ukraine is essentially getting too much attention, right? So there is sort of an inequality here in terms of how much attention is on Ukraine relative to Yemen, Iraq, other conflicts, right? And I do think that this is really, again, something that we need to think about very hard. And I find this very, I find this point compelling when it comes to, for example, migration. Why is it that we are admitting Ukrainian migrants so easily in such large numbers, but European states are pretty reluctant to let in people from Afghanistan or Iraq, right? a similar problem is emerging, maybe you're familiar with this here being in Geneva, with humanitarian aid, how humanitarian aid is being dispersed, who's paying for it and where it's going, right? In the sphere, though, of international criminal law, I do have to say I find this critique rather reductionist and not particularly helpful for the following reason, right? The past 10 years of I guess, international criminal law, the biggest controversy has been that the ICC is targeting Africa, right? The ICC is a neo-colonial court, a racist court that targets black Africans. That's been the narrative, right? It's been a very strong narrative. There's been a lot of pushback against this, but this has been the critique coming from Africa. Now, it's very strange that in the space of a few months, the critique has done sort of a 180-degree pivot, and we're now saying that international criminal law is racist because it privileges white victims in Ukraine. There's something wrong. Something is going on here that doesn't make a lot of sense to me. In the case of Africa, you're focusing on the defendants, who the defendants are, and it's supposedly targeting Africa, black defendants. But when it comes to Ukraine, it's about privileging white victims. So we switch from defendants to victims, right? There's something, this narrative misses something, right? And so, when we think about this critique of too much attention to Ukraine, and the Special Tribunal being sort of the primary example of that we shouldn't be spending as much money on Ukraine. I do think we need to at least keep that in mind, keep in mind what has been going on for the past 15 years, the kinds of critiques that have been leveled at the International Criminal Court and at the International Criminal Justice Project. Because I think it's worthwhile having this conversation, but something is missing in that narrative, I would argue. Right. So there are other things that I wanted to say about that as well. It's a very difficult topic, but it's worth addressing. Right. So yeah, I'll stop there. Right. Maybe yes. Yeah.
Okay, so just so we have enough time for the Q&A, thank you so much for I think, very comprehensive overview of the main concerns regarding selectivity and legitimacy. So with this, we now open the floor for questions. Just one thing that I would ask you is if your question is specifically for somebody, if you can specify, and otherwise you say it's for everyone. So I've seen you first. Yes, please.
So I actually have two questions. My first question is to Natalia. So I want to ask you about your personal opinion on the prosecuting criminal aggressions, not only to Putin and other leadership level, but also for normal soldiers. Because I see Andrew Klotzman has also recently published a paper on foreign policies about saying we can prosecute normal soldiers of Russia for criminal aggressions. And also I think in 2016 there were 2 cases of prosecuting normal soldiers from Russia of criminal aggressions in Ukraine. So I'm wondering what you think about it, and especially do you think it will kind of blur the line between use at battle and use in battle, and to some extent make Russian soldiers more unwilling to act in accordance with the IHL? And my second question is to all the panelists. Maybe that's a little bit follow-up question to Francesco's questions. Do you think because ICC is having a arrest warrants to the Putin right now, and also we are discussing this special tribunal for aggression right now. Do you think at this stage, if we are already start discussing about accountabilities, will this hinder the peace process in this whole Russia-Ukraine war? Because I'm thinking about Charles Taylor specifically, and also Milosevic, and especially for Charles Taylor, if he knew that he's going to be put into a trial after he gave up his house, I don't think this war will end that soon, and that will maybe be more prolonged war. So that question about the timing of this investigation and this discussion. Thank you.
Thank you for this question. Yes, it was a very big problem for Ukraine, these two judgments about 437 articles in criminal court, because in 2014 in Ukraine, maybe we had only near 10% who know what is IHL and how to investigate war crimes, for example. It's really was a big problem for Ukraine. It's a big problem for Ukraine now because we have 75,000 proceeding criminal, but we don't have a lot of resources, human resources, to do this work in the legal sphere. But we try. That's why we teach our prosecutors, our judge, how to use and how to applicable how it should to be applicable IHL in criminal judgment. Or another proceeding in Ukraine, in civil proceeding, for example, and how what is different between jus in bello, jus in bellum. That's why in that if we solve this decision, we see a lot of problem with this decision. We understand that ordinary soldier can be it's big legal problem, and that's why now we try to find this common view to our action, legal action in about establish a special tribunal, about national proceeding, criminal proceeding, and if you would like to see now a judgment on Article 438, you can see a lot of difference between first this judgment and maybe in 2015, 2016. It's more, it's better than it was at first. But we understand, as Ukraine, as a state, we understand our problem as that a lot of prosecutor, investigators, judge don't know about about international law, about international humanitarian law, but we try to change the situation.
Maybe some quick reactions on parts of your questions. On the distinction between, well, not on the distinction, but on the fact that the International Criminal Court or a special tribunal of aggression that were to be created. Of course, if you prosecute the crimes of aggression, you enter the field of jus contra bellum, whether you like it or not. And if you like it, you look at this definition of the Statute of Rome, you're forced to go into it. You have to assess that there was a violation of the UN Charter. In fact, even if the definition had been provided differently, my point of view is that inevitably a defendant in that case would say, wait a moment, my state was acting in self-defense. Whether it is right or not, it's not the issue. The issue is that the International Criminal Court or this International Criminal Tribunal would be forced to make determination of jus contra bellum. That's not necessarily a problem from the viewpoint of the development of the jurisprudence. That would lead to coordination, possible contradiction, but that's not an issue. I'm not concerned by the multiplication of courts and the overlap of jurisdiction. What I'm much more concerned, but I admit it's not an issue I've thought about for a very long time, is really the idea of prosecuting a soldier for the crimes of aggression. It sounds, and I have to say it again, not having researched it deeply, but it sounds wrong to me, completely wrong. Because a soldier, follows order, and it's one thing to say that a soldier should be responsible for war crimes, crimes against humanity, genocide. I understand that completely. The defense of superior orders cannot work. But can you tell a soldier you shouldn't have gone to war? I don't think you can make that. And I think there are very good reasons why the crime of aggression has been identified as a crime that can only be committed by very high-ranking officials.
No, you want
Well, no, well, so just very quickly, maybe because Andrew Clapham is not here, unfortunately, he can't be here tonight, so I'm not going to address his article in Foreign Policy. You should have a look, right? I mean, it's a provocative argument that he's put forward that I think is worth engaging with. I was also surprised when I read it, right? Do we really want to prosecute rank and file soldiers for the crime of aggression, right? But yeah, okay. I won't say more about that. On the second question, right? There's a big debate in the literature about sort of the impact of international criminal justice on peace processes. What it does. Does it force dictators to cling to power at all costs? And the results are, as far as I can tell, inconclusive, right? This is more political science than law. Some people argue for sort of the positive effects of arrest warrants. Others are very skeptical that, precisely what I just mentioned, that this actually will force Putin to kind of hold on to the bitter end. But I do think that the counter-argument that has been put forward by supporters of the tribunal, the Special Tribunal for Aggression in this case, although of course the ICC would have a similar effect, I think one can guess. The argument that has been put forward is essentially that this delegitimizes Putin as a leader, and the hope is that people who are working for him are going to start having second thoughts. Do I really want to be complicit in this illegal war, this war of aggression? And, a concrete example of that was the arrest warrant that we just saw 10 days ago issued against not just Vladimir Putin, but also, I forget her name, Belova, Maria, but I forget her entire last name, who is the commissioner for children's rights or something like that. She works directly for Vladimir Putin. The hope is that people like this, Maria, she's 40 years old. 38. Or, 38, right? Yeah. So, she's a young woman, right? She's a young woman. She has her life in front of her. Vladimir Putin's going to be gone in 10 years, realistically. No, but it's true, right? Vladimir Putin is not going to be around forever. She has something to look forward to, and the question is whether people like that are going to start thinking twice, right? What am I doing here? Do I really believe in this cause of eliminating Ukraine at all costs, extinguishing Ukrainian nationhood? Is this really how I want to spend the rest of my life, with an arrest warrant hanging over my head? So yeah, it's that, I think, is the argument for aggression prosecutions, for indictments, public indictments, so that people in Putin's entourage start thinking twice. What am I doing here?
Thank you. Maybe I give the floor to you because I think you had your hand raised before already. I saw, yes? Do you wish to?
Just a quick question, maybe just to clarify for myself. I'm pretty much sure that if the crime is tried in Ukraine at national level, the date of the crime is anonymously accepted in Ukraine. But because we started the event with the video dated 2022, if the International Tribunal for the Crime of Aggression is established at the international level, what would be the starting date of the crime? Because I think the answer to this question will pretty much affect the discussion.
Patrick, do you want to answer on this? What would be the starting date of the crime of aggression, do you think? How would be perceived? When did aggression start? Do you want to?
My understanding is that it would be 2014, right? That would be the logical start date from my perspective. And I don't think that that's particularly controversial, but I might be wrong. Are you aware of any sort of discussion around this, whether it should be 2014 or 2022?
Would it change the qualification of the events that took place in the Donetsk region from 2014 to 2022? Because the qualification was NIAC, as far as I remember.
Non-international conflict.
Yes.
Mm-hmm.
Right. No, so yeah, in that sense, I'm pretty sure that the judges maybe would arrive at a different conclusion, but I'm not the best person to address that question sort of from an IHL perspective. So
I mean, I think it's an interesting question, but I think we don't have an answer because we haven't seen any decisions so far. So, for instance, Patrick said this might be already from the 2014. My opinion is that it would be very hard to prove that at that point already somebody was really planning, waging, and everything else. I mean, one of those elements that is required for the crime of aggression, but that wouldn't necessarily be a problem. I mean, it wouldn't matter in the terms of whether the tribunal would have jurisdiction or not over the crime of aggression, you know? Or it wouldn't be necessarily that you would say, oh, you've been committing the crime of aggression for 9 years, you should have a higher penalty, or you should have a lower penalty because you've only been committing it for 1 year. I don't think this would influence necessarily the sentence. I think, frankly, that's maybe my opinion, maybe you disagree, but I think the crime of aggression in the case of Ukraine, Russia is so obvious that, as said, I mean, the Special Tribunal for Aggression for sure would be established, I mean, for sure, I guess so. So if you like, retroactively. So for sure it would be since the beginning when the aggression, I guess, started. Otherwise,
Maybe, you know, but just maybe to add on to that, I mean, the crime of aggression with respect to 2014 is manifest. It's Crimea, right? Crimea is the crime of aggression, right? There's no question about that. We can have a sort of a technical debate about whether Donetsk is a NIAC or an IAC, but the crime of aggression started in 2014. That to me is fairly clear.
this doesn't matter even if it's an IAC or IAC for the crime of aggression as such.
Thank you very much. I have a question on behalf of the students of the Executive Master Program who are following you online. Great. They say hi, by the way. Question from us, and in particular, a classmate of mine, Dorai, who was on point. A question that we have is how you would define an international court or tribunal. And so, for instance, would a tribunal established by Ukraine, the UK, and the US for the purpose of the crime of aggression in Ukraine, would it be an international tribunal?
So this is a big question, and it's a big question because, of course, what happened in the al-Bashir saga, but the origins of these questions are actually in the own ICJ jurisprudence, because in the arrest warrant case between the DRC and Belgium, that related to the arrest warrant against an incumbent foreign minister, the ICJ felt it was a good idea to have an obiter dictum in that judgment, in which it said, listen, immunity does not mean impunity, because there might be situations. One situation could be that you could always be tried by your own country. You could be in a situation in which your own country waives your immunity. Of course, if you're at the head of state, you kind of have to waive your own immunity. But one of the last examples was, and there is the question of international criminal tribunals. That was an obiter dictum of the ICJ, and the ICJ said, think about Chapter 7 tribunals, and think also about Article 27, Paragraph 2 of the ICC statute. Now, the Special Tribunal for Sierra Leone jumped on that. They said, oh, we're an international tribunal. We don't have to respect the immunities of the incumbent president of Liberia. And then we saw what happened. The ICC has done the same thing, some pre-trial chambers and the appeal chamber in al-Bashir. So my point to answer your question is, I'm going to try to avoid answering your question directly, but my answer is that it's a meaningless debate, okay? Because the question, it's not meaningless if we talk about a Chapter 7 tribunal. Because if you talk about a Chapter 7 tribunal, you can argue, though I'm always trying to confine the powers of the UN Security Council, you can argue that the UN Security Council can dismiss the immunities, can create jurisdiction where there is no jurisdiction. It can probably do that if you say that the conditions of Chapter 7 are met. On the other hand, the International Criminal Court, they seem to think that they have a power that comes from above and that they're acting on behalf of the international community. I see the International Criminal Court as a tribunal established by states. And that tribunal established by states has no more jurisdiction than what the states can give it. In other words, what the ICC can do, to a large extent, is what a domestic tribunal could do in terms of jurisdiction. What do I mean? I mean that if two states create a tribunal, they can grant that tribunal jurisdiction for crimes committed in the territory of those two states or against nationals of that state. There is nothing wrong in that. The problem is when they try to unilaterally impact the rights of third parties that have not established that tribunal. So there is something strange in the al-Bashir decision, and it is the idea that an international criminal tribunal can do things that a domestic court cannot do. And that I have troubles following up. I don't know if I've been as clear as I should be. Maybe that.
Just maybe in the interest of debate, right, because that's why we're here, I do want to say two things about this, right? So, you know, I think it's fair to say, I hope you agree with me that, you know, this is a sort of a doctrinal, a conservative interpretation of immunities, right? And it's a perfectly valid interpretation that I happen to agree with. But it's fair to say also that, you know, there are two remarks to be made about this, right? The al-Bashir judgment is putting forward a theory that has been now adopted not just by the ICC, but also, you know, the Special Court for Sierra Leone put forward this theory that is critiqued from this positivist standpoint. And, you know, what scholars are saying, some scholars at least, are saying that at some point we, international lawyers, are going to have to accept that if international courts keep repeating the same thing, even if we don't like their reasoning, that is the law, right? That is the law, because it's courts that say this, even if doctrinally maybe the argument is not, you know, 100% persuasive. And I do think that the reason I say this is that the likelihood that the Special Tribunal for Aggression, if it had to deal with immunities, that it would say, we have Vladimir Putin in the dock and we are not going to prosecute him because of immunities, is zero, right? If he is arrested, if the tribunal has custody of Vladimir Putin, he is going to be prosecuted, and I can guarantee you that immunities are not going to stop the tribunal, right? And so, you know, you are going to have this case law that repeats these arguments that I understand, you know, are maybe not satisfactory. And I don't want to get into that further because, you know, it's a really interesting conversation, and indeed we could unpack it further. But, you know, courts are likely to keep repeating these arguments to justify their jurisdiction. And the other thing, just very briefly on immunities, immunities are very unlikely to actually play a role in this whole conversation in practice, because Putin, if he is arrested, he's no longer going to have immunity, right? He's no longer going to be a sitting head of state. It's because somebody's going to send him to The Hague, and in that case, it's likely the Russian authorities, because there's a change of regime or something like that. So yeah, just those remarks.
Thank you. So maybe since I don't want to get suited for inhuman treatment, so I don't want to keep you too late. Maybe I take now 3 questions and then we try to respond them. I saw Ioannis. I also saw a hand here before. So maybe you 3, Igor. I'm not sure if I missed somebody. Then I give the floor maybe to one lady at the end as well. But so Ioannis, you were first, and then.
Thank you very much for your fruitful presentations. My question is related to immunity, so maybe Lorenzo will be more the better person to answer, since his presentation was on immunities. And my point is that when you are going to try the head of the state for a crime, his actions are necessarily attributable to the state. So even if you waive the immunity of the head of the state, because his actions are going to be attributable to the state, you also need to maneuver in a way, and also, at least implicitly, waive the immunity of the state. Because imagine that we have this special tribunal, and they try Mr. Putin and they find him guilty of the crime of aggression, implicitly that would mean that Russia is also guilty of the crime of aggression. But how is the immunity of Russia waived in front of an international tribunal? Yeah.
Perfect. Thank you so much. Do you also wish to ask? We take.
And I guess my question is probably for Patrick, as goes to the question of selectivity. My understanding is that even if Ukraine ratified the Rome Statute, it wouldn't be possible for the ICC to prosecute for the crime of aggression. But would not the case for a special tribunal on aggression be more compelling if Ukraine were to, in parallel, ratify the Rome Statute, because it would demonstrate that it supported the ICC's jurisdiction in its totality?
Perfect. And the last one, there we go. Igor, you want to ask?
Thank you. I would go for the human rights perspective as what's the point of having a specific tribunal for specific country, for specific persons, knowing the outcome already? Will this be really a justice or it just be a political agreement put in a legal terms?
Is for you, so your question for somebody specifically or for anyone? Okay, Lorenzo, do you want to start?
Thank you very much for this question. I should say that an head of state can still act in his private capacity. So, yeah, of course. But indeed, so as we were talking about the crimes of aggression, it's impossible to separate the two. It's impossible because of the definition of the crime we're dealing with. So I'm actually not shocked by the results of the Kampala Agreement, but I don't know the diplomatic process, but I found the Kampala Agreement understandable in its outcome, precisely because of this interstate dimension that is involved. It's not just that there is no jurisdiction over crimes of aggression involving third state. There is actually no jurisdiction over parties that have made a declaration to get out of that jurisdiction. And the point here is that I think we have to draw a distinction. If it's a crime of aggression between two parties to the Rome Statute, we must assume, because of this definition of the crime, not only, of course, that they waive the immunities of the officials involved in conformity with Article 27 of the statute, but also we must assume, I think, that they have meant to waive the state immunity. Because, again, there cannot be no assessment of crime of aggression if you don't assess the responsibility of the state. And if you follow the jurisprudence in interstate disputes involving the monetary gold exception, I believe that basically parties to the Statute of Rome are waiving that objection. They're accepting that there can be an exercise of jurisdiction vis-à-vis their elite that entails an assessment of the jurisdiction of the state as such, in the context of an individual responsibility process. But in relation to a third state, the situation is different. They have not waived the immunities of their head of states, and they have not waived the immunities of the state. That's my view. So to go back at the beginning, a special tribunal tasked with the crime of aggression, it's not a problem of jurisdiction in the end because, well, the events have occurred in Ukraine. The problem is really that we have the immunity of head of state and the immunity of the state. And that's a problem because since we're targeting senior official, I believe they have personal immunity, not simply an immunity that is a substantive law immunity for which there are important exceptions, like war crimes, genocide, and crimes against humanity. But that's just my opinion.
Yeah, right. So I think, it's a question about selectivity and how can we maybe minimize selectivity. We didn't discuss this a lot, but indeed the jurisdictional regime of the Rome Statute is such that right now you cannot prosecute aggression in a situation like Ukraine. And why? With war crimes and crimes against humanity and genocide, as long as those crimes are committed in the territory of a state party, you can prosecute those crimes even if they are committed, as in this case, by a non-state party, by Russia, right, in the territory of Ukraine. For aggression, to just simplify, both, so if you have, aggression is always interstate, right? So it's one state against another, and both states have to be parties to the Rome Statute for aggression to be prosecutable, right? And in this case, neither is a state party. Indeed, Ukraine is actually not a state party. It has made an ad hoc acceptance of the ICC's jurisdiction, but that's different. Now, how can you minimize the selectivity concern? So yes, Ukraine can join the Rome Statute. I think that already would send the right signal. But also, one proposal that is on the table now is that not only do you create the Special Tribunal for aggression for this one situation, it's ad hoc selective justice, and there I'm coming in a way to your question. It is indeed selective. I don't think it's illegitimate, but I do think it is selective. International criminal law is inherently selective, but you want to minimize the potential for such problems in the future, and what you do is simultaneously you start negotiations to amend the Rome Statute, to amend the jurisdictional regime of the Rome Statute so that aggression can be prosecuted on the same terms as war crimes, crimes against humanity, and genocide. This is what the United States, the UK, France did not want, for reasons that I think we understand. They do not want to be held accountable if those countries send in troops to a state party. They do not want to be, those states do not want to be prosecuted for the crime of aggression unless they also accept the Kampala amendments. And what we need to do in a perfect world, if we want to remove selectivity, is you get rid of the Kampala Compromise, as it's known, and you just accept the jurisdictional regime that exists right now for crimes against humanity, war crimes, and genocide, which, in the future, any state that wants to be protected from aggression simply has to join the Rome Statute. That's it. You're creating a fairer system, right? So that proposal is on the table. It's just that it's going to take many years to change the Rome Statute, and that's why we're also pushing for, certain states are pushing for the Special Tribunal to deal with this case of aggression in Ukraine. Amending the Rome Statute, it's going to take 10 years. It'll be too late for Ukraine. This gets to sort of your question, is this all political justice? We're setting up a tribunal to prosecute. We know the outcome anyway. I think that's a fair question to ask about international criminal law in general, right? I mean, a lot of this is political, right? It's influenced heavily by politics, and I think it's okay to raise that issue, but I then think we should also go beyond that and think about the politics that are involved. Why is it that we are doing this? What kind of values are we trying to champion? And so, for me, politics is not a dirty word. Politics can be dirty, of course, right? But acknowledging the politics of international law, of international criminal law, is not necessarily disqualifying, certainly. It's something that we need to engage with thoughtfully and maybe acknowledge it and try to understand why it is that we are doing these political things at the end of the day. Yeah. So I guess that would be my response.
Natalia, do you want to add something, maybe?
Thank you. I would answer for the last question about human rights perspectives. I will talk to stories, historical stories. I was born in USSR, and if you asked some people who were in USSR and post-Soviet countries, the story about Red Terror, about when someone takes my netboard, I didn't say anything. When someone takes my friends, I didn't say anything. Then they went to me. It's about terror. For example, my great-grandfather was killed under collectivization. It's the process in USSR. You can read about this, and it's one story about human rights in totalitarian country. And another one state, it's about Moldova, Transnistria. It's about first Chechnya war and second Chechnya war, and then war was Georgia, then was Ukraine, then now is Ukraine. And who will be the next? It's a very big question. It's about human rights, it's about accountability, it's about security, it's about peace, but it's about international law. It's only for small time this war happened, and this historical events is it's always a part of Russian policy about how they try to be the big empire. It was big empire, Russian empire, and we know about a lot of violation for Ukrainian people. Then it was USSR. It was genocide for Ukrainians. To Holodomors, and now we know about new history of Ukraine. Ukraine is not only one country, and we respect and we always understand what's happened in Georgia, for example, and in Moldova. Thank you.
So I think with this, I wanted to conclude because I'm afraid otherwise nobody else will ever come to the IHL Talks. But I also want to ask if I'm going to break somebody's heart if I don't give him or her the word for the last question. So if you have a question which you will be unable to sleep because of me not giving you the word, now would be the moment to say it. No, everyone will sleep. Perfect. That makes me happy. So with this, I really thank all the panelists. Thank you, Natalia. Thank you, Lorenzo. Really, thank you, Patrick. Thank you, Francesco, so much for this.